Okay, I found this article fascinating. It was in the Sunday Times about business rescue, worth it for many. And it was talking about some high-profile liquidations that hit the headlines over the past year and that they probably painted a negative picture of business rescue. With a failed business rescue of one-time airline fresh in our minds, this new legal route to avoid liquidation may not seem like a good idea. But statistics show that just more than half of all business rescue applications result in a happy outcome. Eric Levenstein, who's the director at Werksmans, joins us now to talk about this. Good morning to you, Eric. Welcome to the show.
Morning.
Thank you. And you are the head of insolvency, business rescue and restructuring practice at Werksmans attorneys. Tell us what business rescue is and how does it differ from a liquidation?
Well, it really is a very interesting new concept that's been going now for some 18 months since the New Companies Act came into force May 2011, in fact. What it does, it gives companies an alternative to liquidation. So simply put, what it does, it brings us into line with what they've got in the United States, like Chapter 11, which really allows a company a breathing space when it enters into a financially distressed position, when it can't pay its debts. It allows a third-party intervening person called the business rescue practitioner who gets appointed. He comes in, has a look at the company, looks at its debt profile, looks at its business, and restructures it by way of a plan. The plan is voted in by creditors. Certain creditors might take a certain compromise in their claims, and the whole objective is to allow the company to be rescued and continue to trade on a solvent basis into the future.
Okay. Now, tell me this then. With the business rescue option, does the director or the person who owns a company, does he or she have a say as to how the process will unfold? In other words, if somebody comes in with capital to rescue the business, or there's this repayment structure, do they have authority to approve or reject anything?
Yeah, well, directors initiate the program for business rescue. In other words, they have to pass a resolution, firstly appointing their business rescue practitioner of choice, saying to all their creditors, look, we are in financial distress, we are appointing this practitioner. Please understand that you can't deal with us on the same basis as you did before. So directors, once they've done that, they really hand over the ultimate running of the company to this practitioner. He comes in fairly cold, so he can't just discount what directors have to say and how they operate the company. So he kind of sits as a supervisory person who works with the directors in the business rescue process, firstly to formulate the plan and thereafter to get it through to the vote. And directors would very much play a role in that process. So they're not completely cut out like you'd have in a liquidation scenario when a liquidator takes over completely and directors are removed.
Okay. What are the benefits then of business rescue? Why should a company choose this option instead of liquidation? I know that there are circumstances where you can't avoid liquidation, but why is business rescue better?
It's all about getting in pretty early. There's no way that you can have a successful business rescue where you are on the verge of financial collapse. So therefore, the Act talks about a 6-month period where directors have to say to themselves honestly, look, are we going to be able to pay our financial obligations in the next 6 months? If not, let's consider business rescue. It gives us an opportunity to have a breathing space, to allow all creditors to be dealt with on a similar footing. It stops all litigation against the company. So there are a lot of advantages to directors making that call. Obviously, they've got to be convinced that business rescue will work, because what you're doing is you're telling all creditors and all third parties out in the market that you are in financial trouble. If business rescue doesn't work, the ultimate result would probably be, and we've seen this oftentimes now, is liquidation. So you've got to be very sure, if you're going to embark on a business rescue process, that you are going to be able to rescue the company. Otherwise, you most probably will end up in a liquidation scenario.
Okay. And Eric, just teach us something here. What is the role of the court in the business rescue process, and how does it differ from the liquidation process?
Well, there's two entries into business rescue. I've already dealt with the one where directors would pass a resolution entering the company into business rescue. The other, of course, is any affected person, which would be a creditor, a shareholder, even an employee and a trade union, could apply to the courts to say, look, we want this company to go into business rescue. Let's appoint our business rescue practitioner to be appointed to allow this company to be restructured. if that doesn't work, the judge may decide, look, he doesn't think business rescue is in fact going to work here, I'm putting it into liquidation. So again, if you make that call, creditors might decide it's a better option to go into business rescue, but the risk always is a judge might not believe the application holds merit, and he might in fact convert it into a liquidation. So the courts have been playing significant roles and have been now for some months, and we've seen at least 40 to 50 judgments on the topic. So it's really a concept that's developing through precedent in our court system.
And I imagine, Eric, business rescue doesn't necessarily mean that assets can always be saved.
No, assets can be sold off by a practitioner, or let's say loss-making portions of a business might be sold off. Because if that's the way that the company should be restructured and it can rescue the company by doing that, a practitioner would certainly consider that position. In a liquidation as an alternative, their assets are sold off at negligible values, and you've got a much lower dividend in a liquidation than you would get in a business rescue for creditors. So a lot of creditors are saying to themselves, well, let's try business rescue. It might result in a better dividend than we get in a liquidation, and therefore we're seeing a proliferation now of business rescue applications being made through our courts.
So given that scenario that you've painted, I would imagine then that some business rescue processes are not voluntary. They would arise from a situation where a company tries to file for liquidation, and then the affected parties, the creditors, would go to court then and force the business into a business rescue option.
100% correct. In fact, you're seeing most of the court interventions, in other words, the conversion from a liquidation application to business rescue, is happening in exactly that scenario.
All right, I'm chatting to Eric Levenstein, who's the director at Werksmans. Eric, I always battle with this.
That's okay.
Werksmans. So it's two plurals, works and mans. Werksmans, and he's talking to us about business rescue. If you have any questions for him, give us a call. We're comparing liquidation, business rescue. What is the better option? What do you need to know? We'll talk about the costs of the process, who's involved. 021 446 0567 011 883 0702. Stefan, I understand that you are a business rescue practitioner. Good morning. Welcome.
Morning. Thank you. Yes, I'm also a practitioner, also in the early days of Business Rescue Chapter 6, although I must say I'm very, very positive about the act. I think it's long overdue. The economic value that business rescue, if done correctly, can save, and also the jobs that it can save, is immense. There are some challenges, however, with regards to funding a business with, something called post-commencement funding. I think Eric will be able to elaborate on post-commencement funding and how the need for it. Unfortunately, it's going to be a couple of months before government and the institutions come to the practitioners, because we've been getting a lot of flack from the banks. I must say, the banks treat us with a lot of hostility, which is not always nice and not always welcome, and it does make our job very difficult, I must say. Maybe Eric could also discuss that, the bank's role and how they take it. But my experience is if the banks don't want it to work, they can make it very difficult for us.
All right. Eric, any thoughts?
Yeah, I think that's a pretty fair comment. I think business rescue is not for everybody. In other words, there's certain companies that would probably file for business rescue, and maybe there's a situation of abuse of the system in the sense that those companies don't really have any opportunity to get post-commencement finance, for example. So once you enter into the process, you can't continue to run the company because they've just run out of money. So a lot of the banks are saying, well, those customers, what they really are looking at, or where we have an exposure, they're really looking to buy into this debt moratorium. They just want a debt holiday, and they're not the proper candidate. Whereas we've seen a lot of bigger companies, and I'm not saying they have to be huge companies, but medium-sized to larger companies where it has been working and where there is post-commencement finance put up. And there the banks have been fairly cooperative and very much buying into the process, where they believe that, in fact, there's going to be a better outcome through the business rescue process.
Let's go to, is it Stephen in Q? Hi.
Hi, Redi. Yes, a question for your guest. I'm a landlord and I have a tenant that's under business rescue. They've been under business rescue since November last year. We haven't received one rental for the period while they've been under business rescue. They're still trying to get post-commencement finance, and up to date have not been able to get anyone to put finance or to come up with a solution. How long do we keep the tenant occupied in the premises? Why can't we evict them? How much protection do they get from business rescue?
All right. I'll tell you what, Eric, we'll answer that one after the news. Stephen, we're not ignoring you. We'll call you back so that you can hear the answer. We have to take a break and then news. I promise you, we are going to deal with your question. And Lerato in Sandton as well, we will schedule your questions for just after the news. Eric, if you can stay on the line for us, please. 6 minutes past 11 o'clock. And yes, those of you who are still waiting for your answers to the business rescue conversation and questions that have been asked, don't worry. After we've played this particular great game, we'll resume that conversation and ask and get an answer to the question that was asked about a tenant who is undergoing business rescue and has not paid any rent. So what are the options? What recourse can a landlord take? But right now, let's find out who the cleverest of them all is. All right, so let's get an answer to the question. In case you've just tuned in, and that's how it has been for the month. We've got the brain of 702 and Cape Talk, so it does interrupt programming somewhat. But we've been chatting about business rescue, that it's worth it for many, but we want to understand, what does the process entail? Who gets involved in this? What is the role of the court? What are the costs? And is this a better option for your company if it's in trouble, or is the answer liquidation? And what is the difference between the two? Eric, thank you so much for staying on. Eric Levenstein has been my guest, director at Werksmans Attorneys, and we are talking about this with him. Eric, the question was about a tenant and landlord. What is the answer?
Well, it's a very interesting point, because here you've got a landlord. He's got a tenant that's been paying him rentals. He now goes into business rescue. Now, what does he do? Now, the first thing that the landlord needs to look at is his lease. The lease might have a provision which says that if your tenant files for any form of recovery process or restructuring or liquidation or business rescue, you could terminate the lease, and then you'd be able to at least not have a situation where you're on an ongoing position where you don't know where it's going to end up. Most leases, unfortunately, don't have those provisions. So therefore, the landlord is going to have to be in touch with the business rescue practitioner, find out if there is post-commencement finance, find out why he's not being paid. Is he going to be part of the plan? He needs to engage on a constructive basis with the practitioner to find out why he's not being dealt with. Now, if it's going on a never-never basis, he's entitled to apply to court as an affected person, being a creditor. A landlord would be a creditor, and ask the judge to come to his assistance in respect of putting an end to this process if there is no post-commencement finance, and putting the company into liquidation.
Okay. All right, that makes sense. Let's go to Lerato in Sandton then. Good morning to you, Lerato.
Morning. I sit on a board of trustees, and late last year, we decided to put the institution that on whose board we sit into business rescue. Through the process, we've realized that the competence of the business practitioner in particular can have quite a significant impact on the success or lack of the process. So my question is, given that the practitioner's fees are legislated, what comfort do we and creditors have in terms of the competence of business practitioners, and in particular their competence in terms of industry knowledge? Because that we found is really very important in terms of the ability of the business practitioner to come to terms with the complexity of issues that are faced within a fairly short period of time, in line with the legislative process. So what is the quid pro quo? I mean, we have to pay legislated fees, but what exactly are we getting in return, such that the process itself is not diminished by practitioners who are not adequately competent to run with the process?
Eric, what do you think?
Well, firstly, I'm not a practitioner. I'm an attorney that obviously advises clients and practitioners from time to time in the process. But it's a very, very important and fundamental element to successful business rescue, and that's the skill set of the practitioner that's appointed. Now, what happens is, as I said earlier on, the resolution would appoint a practitioner, or the court might appoint the practitioner. Generally speaking, these guys are accountants We have got some lawyers that are taking appointments, but this is not a situation where you can just come into a company cold and think you're going to be able to run it. Or, for example, it's a liquidation scenario where a liquidator, all you'd have to really do is just sell off assets. The role of a practitioner is quite different, and it's a very important aspect that before one appoints a practitioner, you need to meet with that practitioner as creditors and say, you know what, this is the right guy or he's not the right guy. Does he have the skill set? What does his CV look like? Has he done this before? And not just go with someone who maybe is just on the list at CIPC, being the company's office. It's very important that these practitioners engage with creditors up front. Before you appoint that person, he must have some form of turnaround competency. If not, it's going to be a disaster. And in all likelihood, if it fails, the practitioner has a duty to put the company into liquidation. So I think the choice of the practitioner is vital. And if the person is not delivering the goods, you can apply to court to have him removed.
All right. Thank you very much, Lerato. David in Cape Town, hi.
Hi. I'm so pleased that this last caller raised this issue. I work as a practitioner, but really as a turnaround consultant, and I do take on practitioner roles. And my background isn't insolvency or law or a liquidator like, unfortunately, most of the practitioners in South Africa. And if I can just make some recommendations to your listeners, that a practitioner has to have integrity. He has one chance to establish himself with all parties involved with this matter. Two, he needs to have a good strategic focus, and he has to have outstanding interpersonal skills. Because whenever there's a problematic situation, people try and go into their fallback positions where they try and protect themselves. And my analogy in any turnaround situation is that people need to be like they're in a scrum, in a rugby scrum. Everybody needs to feel a bit of pain, and everybody needs to be pushing in the right direction. And a good practitioner can facilitate that. He needs to be an outstanding listener. And really, he needs to be able to tell people with authority what they don't really want to hear. Because by and large, business owners, when they have problems, try and do what they did before, but just harder and faster, which means they just hit the wall a lot quicker. And the practitioner also has to be part of that solution. Our view is we don't necessarily charge tariff fees. We do not want to be part of the problem. And often some fees, the lawyers, the practitioners charge very big fees and expect payment reasonably early on. And my view is it is a risky process. You're asking creditors to take a risk without necessarily taking equity. And the practitioner needs to be part of that solution mindset and effectively lead people through how he engages with people and how he charges his fees. And ultimately, what they really need to be looking for is creating a sustainable outcome. So, to be honest, sometimes the business owners are the problem. They don't want to engage with difficult choices. And then the practitioner must be ready to remove them and put in other management or control mechanisms. And that's something that I have done. And it's an uncomfortable space, but it also provides an opportunity for growth space. And a lot of my clients who've been through the process have been quite frank that they never thought that what would transpire, that they found it an incredibly growth-oriented experience. And many of them have offered to mentor new clients who've come our way to assist them on the softer emotional aspects of it, because it really can be especially for small business owners where their business is in many situations the center of their life. Everything can get turned on its head very, very quickly, and it's a very challenging experience. But the outcomes are miraculous. I've had marriages saved. I've had guys keep their homes, their investment properties. I've had businesses that are trading substantially better than they ever traded before, or for substantially different infrastructure. It's a pity some of my clients haven't come online. They're obviously too busy working. But I think that you will hear that the experience has been an incredibly positive one.
Okay. So, Eric, it does depend on the quality, the integrity of the practitioner that you choose as a business, amongst many other things that David said this morning.
Yes, I think that's correct. And I agree wholeheartedly with the previous caller, is that if the practitioner is not open-minded and has some background in restructuring, and particularly in how to engage with management, and not only with management, but with creditors. Creditors do not like to be in this situation where they're being asked to take a financial haircut on claims. So I think it does come down to who is the practitioner, how much experience has he had. And as the previous caller said, business rescue is not for the faint-hearted. It is confrontational at times. As the previous caller said, people do not want to hear some of the things the practitioner has to say. So it is a whole new ball game. And unfortunately, we don't have any examinations yet for practitioners to be accredited to become practitioners. What happens is the company's office would appoint a practitioner on an ad hoc basis per appointment in a company that's in business rescue.
Mm-hmm. And then, Eric, just as far as tax matters are concerned, because it's not just about the creditors, it's not just about saving jobs, there's also SARS there. When you're undergoing business rescue, what does this mean in terms of the taxes that are due to the receiver? Must they also wait until I don't know, does it place a moratorium on the legal proceedings against you? What does it mean?
Yeah, well, firstly, there's a moratorium on all proceedings. So no one can sue the company while it's in a business rescue proceeding. No one can apply for the company's liquidation. And SARS, or the South African Revenue Services, is in basically the same position as all concurrent creditors. And that was recently handed down by our courts. And a ruling was made that in business rescue, there's no preference for SARS. SARS would be as concurrent as everybody else. In liquidations, SARS are preferent creditors and they would be paid before concurrent creditors. So that is a big shift away from where you'd be in a liquidation scenario. So, it's all new, and obviously the law's developing as we go along.
Mm-hmm. And then what I do want to ask you as we wrap up the conversation, what is your responsibility as a company to your clients, to people who are doing business with you? Because I've often been taken aback when I'm reading newspapers and I find that passengers have bought tickets. I was also in that situation with Nationwide, buying tickets, and then the next day there's this big story about the company being in trouble. Of course, the stories have been building up and brewing, but nobody actually appreciates the magnitude of the problem. Whereas if the company had said so earlier, although perhaps that has an implication, it affects the brand, what are you obliged to do as a company that is applying for business rescue? Must you inform your clients and your customers?
When you're talking about the company, we're talking about the board of directors. Now, directors have a significant role to play when their company is bordering on a level of financial distress, because if they don't take it seriously, there might very well be personal liability down the road for those directors. Now, obviously, if you're incurring ticket sales, for example, on an airline, and you know that the next day you're going to file for business rescue, there are elements of recklessness, maybe an intention to defraud creditors, all of those aspects which form part and parcel of our New Companies Act. So directors must be very careful if they're reaching that stage of financial distress. They need to take either financial advice or legal advice as to what their particular liability might be if they don't take action. And our New Companies Act talks about reckless behavior, incurring credit, knowing full well that you can't pay that debt back to your creditors, for example. And certainly that might end up in a situation where those directors are sued personally. Okay,
Eric, before I let you go, I don't know if this will make you laugh or depress you, but why not? Freddie says, is there business rescue for the country because it's going down?
I've got no comment on that one.
Neither do I, quite frankly. Thank you so much, Eric, for indulging us and giving us more time than what we'd asked for. I really appreciate it.
Only a pleasure.
Thank you, Eric Levenstein, who's the director at Werksmans Attorneys, and he deals with business rescue. The level of interest in this, especially in these tough economic times, it's been wonderful just getting the feedback. Obviously, we're not enjoying the fact that your business is going down, but there's certain options that are available for you, and business rescue may just be the option. And I remember when debt review and debt counselors first came on the scene, and we talked about it in our consumer focus, and so many of you phoning, giving us your experience. I also read a few years down the line that there were some problems with some debt counselors. Perhaps we could revisit that particular topic just to find out how it has worked. Has it benefited you if you've applied for a debt review or debt counseling? Because in this article, as I said, in the Sunday Times, that was published, I think it was a couple of weeks ago, it said that much like debt review for individuals, the business rescue is intended to give ailing businesses some breathing space from creditors. Now, let's not misrepresent things and say it's just about giving you some breathing space. You still have obligations, and it's not supposed to be, as Eric rightly said, it's not supposed to give you a debt holiday where you kind of abdicate your own responsibility to your creditors. This conversation will be made available as a podcast.